People's Law School is brought to you by Prince Glover Hayes.
When you need an attorney, experience matters.
Past success matters.
Attention to detail matters.
Prince Glover Hayes is celebrating 40 years.
40 years as a civil litigation firm.
And delivers over 100 years.
Over 100 years of combined experience.
We've been able to obtain some of the largest jury verdicts and settlements in the state of Alabama for our clients.
We will fight.
We will fight.
We will fight to make sure our clients
get the justice they deserve.
Here at Prince Glover Hayes, we counsel.
We advocate.
We litigate.
And we are devoted to helping you.
Hello once again, everyone, and welcome to People's Law School. Along with Bob Prince, I'm Mike Royer. The program is brought to you by Prince Glover Hayes Law Firm here in Tuscaloosa. And on this program, we deal with issues that are important to you and your family. Our topic on this program, the anatomy of a trial. And your host, Bob Prince. Bob.
Thank you, Mike. And welcome to People's Law School. What an honor it is for me to talk to you tonight about the anatomy of a trial. Tonight, I thought it might be interesting to go behind the scenes, to let you see how the lawyers see a trial, to let you know what the lawyers are trying to do in a trial. What are their objectives? We'll break it down into the 4 basic segments of a trial and analyze each one on how to do it properly. So if you ever call for jury duty, you can say, well, that lawyer's not doing it right, according to Mr. Prince. So let's just begin this way. When lawyers go to trial, what are they trying to do? Well, there's one word to keep in mind, and that word is persuasion. They're trying to persuade the jury if it's a jury trial. If not, it can be a judge trial. The trier of facts. The jury decides what the facts are, and if it's just a judge, then he or she does that. So the lawyers are trying to persuade, I'll use a jury, persuade the jury that they are correct in what they're saying. There's 2 sides. One side says yes, the other side says no. Who's going to win? So that's what a trial is all about. It's persuasion. So what about jury duty? Some of y'all, I'm sure, have been on jury duty or maybe have seen a trial. I think everybody has seen O.J. Simpson, the state versus O.J., or at least segments of it. And that was a trial. Most states don't allow cameras in the courtroom. California does. Alabama does not. It's generally up to the judges in federal court, but most of them don't allow cameras inside. Why not? They think it's disruptive, and it can be. So just bear that in mind when all these trials start in Washington, D.C., that you hear about on the news. You probably won't be able to go inside the courtroom. So jury duty, you're sitting out there, the lawyers call it a panel. And what are we doing? People say striking a jury. That's right. We don't get to choose who is on the jury. We get to strike off people we don't want on there. And so I term it the least egregious people to both lawyers is who gets on the jury. In state court, we have 12, sometimes 2 alternates. Federal court, you have 6 in civil trials. Now, how about the questioning? Well, the lawyers ask a lot of questions. It's called a voir dire, Latin term, but it just means speak the truth. So we want to know something about your background. Have you ever been involved in a lawsuit like this one? Are you related to the lawyers, the witnesses? All that is information to tell us, I want to strike that juror. Anybody have any questions?
From Birmingham, Juliet says, while we realize the importance of serving on juries, are there ways for people to legitimately get out of jury duty?
Absolutely, there are ways to do that. The circuit clerks are really the ones that are in charge of that. The circuit clerk of the county. People call, you get sick. Sometimes you have a work job, a duty that you just can't get out of. Suppose you're taking care of an elderly parent. All these are legitimate reasons. So the clerk actually makes that decision, and if you're not satisfied with it, you can go to the judge. Hey, Mike, I understand we have another question.
Bob, this one comes from Woodstock. Keith asked this question: how does jury selection work in this respect? How do they determine if someone is going to be a good juror? How do you determine that as a lawyer?
Well, that's a great question. You know, you really can't tell if somebody's going to be a good juror. Lawyers can generally spot who's going to be a bad one. The ones that are going to be against our case, we can kind of ferret those out. So jury selection is not, we don't get to pick who we want. We get to strike off who we don't want, and that's how it works. Okay, so let's say the jury, you're lucky enough to get on the jury. The first thing that's going to happen is the judge tells you just briefly what an opening statement is. And the judge will say it's a roadmap, it's a blueprint. It's what the lawyers hope to prove in the case. Now here comes the fun part. The plaintiff, whoever files the lawsuit, goes first because they have the burden of proof since they've sued. So the lawyer stands up to do an opening statement. You'll hear the term opening argument, but it's not an argument. It's not supposed to be. It's supposed to be, here's what happened. Now let me give you the latest and greatest technique from the lawyers. Not all lawyers are doing this, but the ones that are really on the cutting edge, they tell a story in the opening statement. Like Mary had a little lamb. I mean, they don't get up there and argue. They just say, what happened on April the 4th of last year? And then they start the story. They'll say, little Johnny was playing out in the yard when his mother called. Now notice this is in real time, first person. That's how you do it. Why? That's how we learn. We learn from stories. Even when you were a child, people told you stories. We watched TV shows. They're stories. So we learn from stories. That's why, and this is recent, y'all. This is in the last 5 years. Before that, we didn't talk about stories in the opening statement. All right, so the lawyer's goal is to keep it interesting and effective. Those are the two words that the lawyers better be thinking about in the open. All right, the next stage, and I'm going to flesh this out a little bit more for you in a second, but the next thing is direct examination. What is that? That's when the lawyers prove their case. If they don't prove it then, they're going to lose because the judge can toss that case midway in the trial. Now, what do I mean by that? Well, I call a witness. Here's why you're supposed to do it. The lawyer becomes invisible. Supposed to. That's the correct way. Not all lawyers do that. The focus is supposed to be on the witness. Now, how does the lawyer make the jury like that witness? Very few lawyers do this, but here's how you should do it, how they should do it. They should act like this is the first time I've ever heard this testimony. They should not lead, but most lawyers lead. What do I mean by lead? They'll say, you were down on the corner of 4th Street on June 21st, right? Well, who's testifying there? The lawyer's testifying. The witness just says, yes, no, yes. You're not supposed to lead on direct, but lawyers do it all the time. My theory is lawyers don't trust the witness to get the information to the jury. So the lawyer does it. That's the wrong way to do it. The right way to do it is to say, were you at the corner of Martin Luther King Drive and 6th Street last year? Yes. And then they ask open-ended questions to make the witness talk. Witnesses are scared. They don't want to talk. How do they do that? The questions like, what were you doing there that day? Why were you down there? See, the witness now has to narrate and talk, get the nervousness out. The lawyer becomes invisible. That's how you're supposed to do it. If the next trial you watch and see if the lawyers don't lead on direct. And it is objectionable. Some lawyers will object to it. And if the judge says sustain, that means the lawyer objected and won. If he says overrule, no, he lost. But you're not supposed to do it, but lawyers do it all the time. Let's go to cross. Cross-examination. This is my favorite. This is the only time in the entire trial where it's person versus person. The only time. In the opening statement, the lawyer's up there by himself talking. Closing argument, the lawyer's up there talking. Direct, I've got a friendly witness there, my client. Cross-examination, I've got to question the enemy. It's man versus man, woman versus woman. This is where the fight is. And everybody knows it and everybody watches it. So what is the lawyer trying to do in a cross-examination? I can tell you right now, they want to control that witness. They don't want that witness talking on cross. So how do they do it? It's the opposite from direct examination. The lawyer should be, quote, testifying. He should be leading, because you can do that on cross. So the cross would go, like, Mr. Swindle, isn't it true you were down on 4th Street and Martin Luther King, isn't that right, last year, June 15th? See how the lawyer's planning all the facts in that question? And so that's a cross-examination. What else is the lawyer trying to do? Every now and then, a witness will have information the lawyer needs. Well, when does he or she get that information? Because we know we're going to bloody the witness up if we can. Well, it makes no sense to attack a witness and then ask the jury to believe what the witness is saying. So you construct the house before you demolish it. We can do a constructive cross before we do a destructive cross. So the constructive cross might be nice and sweet, you know, it's like, well, Lieutenant, you did a crime scene investigation, didn't you? Yeah. And you put tape around, yes. You tried to interview all the witnesses, yes. You interviewed Mr. Smith, yeah. See, the lawyer needs that into the record. But once he constructs that, then you can hear a tone of voice that's different, body language that's different, and he's starting to control, or she is, control that witness. And it would be something like this. Well, as a matter of fact, though, you did not interview John Smith, did you? See, wanting a yes or no. I'm going to leave it there. You see the difference. Directs, friendly, you proving your case, get the witness talking. Cross, no. The witness does not talk. The lawyer is, quote, testifying if they're doing it correctly. All right, what's the last phase? Last one, closing argument. On closing argument, here's what the lawyer should be doing. And look, y'all, I've taught this for years and years, taught trial skills. And I've tried cases, and I can tell you, I've been all over the country and heard critiques from lawyers, you know, who are critiquing law students who are doing opens and closes, directs and crosses. And I've heard these critiques, and I know how they do it in Seattle. I know how they do it in New York. And I can tell you, most lawyers don't do closing argument correctly. Here's what they do. And if you're ever on a jury, you see if I'm not right. The lawyer get up there and say, okay, now you heard from Officer Jones, and he came in and he told us that he went down to the scene that night and da-da-da. He's just recapping and rehashing the testimony. The jury just heard that testimony. This is what I tell the law students out there when I'm teaching them. I go, that's the same thing as going to a movie with two of your friends, walking outside the movie theater and turning and start telling them about the movie they just saw. Who wants that? Nobody. But yet lawyers do it all the time. What should they be doing? Well, a lawyer should be doing this. He should be, and she should be saying, I know some of these jurors are for me because they've smiled at me, they seem receptive. Some of them are not for me. I could tell. They frown, they look down, they won't make eye contact with me. So I think what I'm going to do, because I know they're going in that jury room. When I get through talking and the other lawyer gets through talking, they've got to go in there and deliberate. So I'm going to arm my jurors with good arguments to make back there. I'm going to give them something they can use. Now, how can I stand up here and tell you I know how to do it, but these other lawyers don't? We've asked hundreds and thousands of jurors. That's how I know. We've done surveys. We've done focus groups. And we say, okay, you were on a jury, and so now how about that closing argument? And they go, oh, you know what? The lawyers just got up there and told us what we just heard. I mean, they think we're stupid or what? Here's what we want. We want something new and useful that we can go decide this case on. See? And so the lawyers that did all these surveys said, aha, okay, if that's what they want, that's what we're going to give them. Useful tools to decide the case. Now, you can't do a good close, I don't think, unless you take the law that the jury's going to hear and plug in the facts to fit that law in the closing argument. You do it a little bit in the open, but you do it a lot in the close. But all that pales in comparison to what I was telling you, because the real fight starts in the jury room. It's not in the courtroom. And the lawyers are just now getting around to understanding that we need to give our people some tools to work with. Mike, I understand we have another question.
Bob, this question comes from Mark here in the city. Does the length of a trial affect the outcome at all?
You know, I really don't think it does. The length of the trial, if it's a long trial, what that tells me, you have complicated issues, you have multiple parties, and it could be more difficult for the jury to reach a verdict. But in terms of whether they're more guilty pleas, not guilty, verdicts for plaintiff, verdicts for defendant, I really don't think the length has that much to do with it.
All right.
Now let me go back and just talk to you just a little bit about some of these phases that can get kind of interesting. Before we ever come into court, all right, we do discovery. We take depositions, we interview witnesses, and we kind of know what the facts are. And that allows us to do an opening statement with some confidence. We also know the bad things about our case. We know what the other side is going to say. So there's something called inoculation. We want to get that news out to the jury before the other side does. We don't want them telling. So it's like you get in trouble in school when you're in high school. Do you want the principal calling your parents and telling them what happened, or do you want to tell them so you can spin it? Well, that's right. You want to tell them. And so we inoculate on direct. It goes something like this. Let's suppose my client made a contradictory statement. I know this lawyer's going to bring it out. So I say, Ms. Jones, you've told the jury today that you didn't see that light. Is that right? That's right. Have you ever testified about this case before? Yeah. Where? Deposition. Yeah. Did they ask you this question? Yeah. What was your answer? My answer was, I thought it was yellow. Well, is there any reason, Ms. Jones, why you told yellow and now you're saying you don't remember? Yes, I was nervous, you know, whatever. See, so she's going to explain it. If I don't do that, let's just suppose I just ignore it. Because, you know, it's kind of unpleasant to tell the jury, hey, my client told something different earlier under oath. If I don't do that, here's how it comes across when that lawyer cross-examines. Now, Ms. Jones, this is not the first time you have given sworn testimony in this case, is it? No, sir, it's not. In fact, you came down to my office and we asked you questions. Yep. I told you if you didn't understand the question, you just tell me and hey, I'll rephrase it, didn't I? Yes, sir, you did. And we had a court reporter there taking everything down. You did. And you knew it was under oath. Yeah. You had your lawyer sitting right beside you, didn't you? Yeah. But on that day, you didn't say that you couldn't remember the light, did you, Ms. Jones? Oh. In fact, and he look at the jury now, he goes, in fact, you said it was yellow, didn't you? He's looking at the jury, see, like he wants to play with the jury. It's like me and you versus them. So y'all see the difference? If I don't take the virus away, if I don't give my client a little shot of that, they're going to eat her up on cross. But by doing this, the jury's already heard it. By inoculating, they know. So if you ever see a lawyer bring out something that doesn't sound quite good for his client, that's what they're doing. It's called inoculation. All right. Let's see what else. On cross-examination, you know, I talked about this a little bit about testifying. The thing that kills a cross, there's two things. So lawyers who know what they're doing try not to do this. One is badgering the witness. Badgering them, that's what it's called. Being too rough on them. Here's what I say, and good lawyers, experienced lawyers I mean, know this. They say, whatever speed, picture a fan, and if that witness has got their fan on 6, 1 to 10 speeds, the lawyer should only have theirs on a 7. If that witness has that fan on 2 and that lawyer's on 8, I don't care what the testimony is, the lawyer's going to lose that skirmish. Now, what am I talking about? A 2 would be a little old lady that talks meek and mild and sweet. Low voice, non-hostile. That's a 2. And what's a 9? What's an 8 or a 9? Well, Ms. Jones, you didn't do so-and-so, did you? See, now you can, A lawyer can get away with that a little bit with maybe a police officer or an expert witness, but you can't get away with that with Ms. Jones. And so notice the fan speeds on these lawyers. Because look, we go to seminars. They all know this rule, but a lot of them violate it. The other rule is keep that cross short. Now this one gets violated a lot because lawyers go on and on. They think, I've got to, if the witness testifies to 10 facts, a lot of lawyers think they've got to cross them on 10. Here's what I tell the students, no you don't. One bad apple spoils the barrel. All you have to do is impeach that witness on one thing. Impeach means make them look bad, make them look, discredit them, make it so the jury gives their testimony no weight or little weight. Once I do that, the rest of they've forgotten the rest of it. And I usually point it out by saying something like this. Wouldn't it be great if you could just say on cross-examination, isn't it true, sir, that you just got out of prison for perjury, for lying in court, where you had to serve 10 years? Do I need any other questions? No. No, I don't. So I don't care what they say. And I try to teach this, don't cross on every point. The jury doesn't want to hear it, and you know, hey, you're killing yourself by doing that. So make it brief, make it effective on cross. Okay, Mike, I understand we have another question.
A good question from Dan in Eufaula tonight, Bob. How important is it to have a jury consultant involved in a trial?
Well, you know, it's very important, especially if you watch Bull, because that TV show is all about a jury consultant. Lawyers in bigger cities and law firms that have more money utilize jury consultants. Tuscaloosa lawyers, every now and then, one will be utilized only because it costs so much to do that. I do think they're valuable, but it's one of those things that, you know, you can try your case and win your case without it. Here is something, I mentioned this thing about the story, and I mentioned it's new. Before lawyers started doing opening statements, here's the only good thing that we really learned before the story got to us, before, you know, to tell it in a story. We were all taught to some degree or another, and this may surprise y'all, I don't know. When I try to persuade you, like tonight on this talk, if I'm doing good, do you know that all the studies show, all of them, that it is not what I say, it is how I say it that persuades you? Supposed to anyway. What am I talking about? Well, I'm saying, have you noticed that I am consciously not looking at many notes? I'm trying to make eye contact with you and I'm talking to you. That is the number one rule that's violated by lawyers. They're so afraid they're going to forget something. They take the notebook up there. They don't make eye contact with you. They're reading it. You know, it's like, no, it's not what you're saying. Use open body language. Like this good thing, this is glass. If this was not glass, you'd see me out here on the side of it. Because this is an impediment. It's a barrier between you and me. No barriers. Look at my hands. Open. Everything's open. No hands like this. No hands in the pocket. I'm looking at you. I'm talking to you like I don't have anything to hide. This is called open body language. It's non-verbals. That's what the lawyer calls it. Verbal if I talk. Non-verbals is if my facial expressions. Okay, Mike, I understand we have another question.
Monet asked this question from Walker County. What does it take to get a plea deal? What leads up to that?
Okay, a plea deal is generally in criminal court. And here's what leads up to it. The courts are clogged. There's a backlog of cases. And so the judges force the district attorney and the defense lawyer to come together. And the district attorney has to make an offer to the defense lawyer. The defense lawyer doesn't have to take it, but they have to make an offer. So there's actually a time that the judge makes the parties come over there and gets them together, gets the decision makers there, and makes them talk about a plea. And so that's how it comes to be. If the district attorney looks at it and thinks he can win the case, then he's not going to offer a whole lot. But if he thinks that he's got some problems, then he might offer a more lenient. But let's go back to that direct. How can I make a direct examination seem interesting to the jury? I can act like it's the first time I've ever heard it. Even though I've heard it, and by the way, I was going to tell you all this. You got some lawyers that just kind of go over to the courthouse and try the case. They haven't practiced anything with the witness. On the other extreme, you got lawyers who film witnesses. They practice these things. And they show the film to the witness and say, look now, you're doing it wrong, do this. Take them to the courthouse, put them in a chair. So on the one hand, you got lawyers that don't do much, and you got on the other extreme lawyers that do a whole lot. Whether it's a little or none, a lot or none, here's what I say you have to do to make a direct interesting. You have to act like you've never heard it before. It's like, Miss Smith, or what did you see that day? I saw these two cars wreck. They wrecked? Well, tell us specifically. What do you remember about it? You see how it's like, I don't know what her story's going to be. Well, Bull, I do too. I've gone over it with her 10 times. But if I can pull it off that, I'm interested in this, then the jury's going to be interested in it. If I'm back there monotone, like, yes, ma'am, and what happened next? What happened next? What kind of question is that? Why don't we just put her on the stand and say, did you see a wreck? Yeah. When? But what happened next? She answers. What happened next? She answers. That's not a direct examination. I mean, that's a recording. So I'm trying to give you some insight. Okay, Mike, I understand we have another question.
Chelsea has this question from Tuscaloosa, Bob. How often do cases actually go to jury versus being settled before ever going to trial? Do you keep track of that?
We do. The court system publishes numbers exactly. We know exactly how many cases are tried, how many are filed. The vast majority of cases don't go to a jury. They're either settled at a mediation or they're settled on the courthouse steps once the lawyers see who the jury is going to be. I've even seen cases settle in the middle of the trial, and even while the jury is out deliberating, cases can settle. So I would say 96, 97% don't go to a jury. TV trials, let me slip over into that for just a second. They're not as unrealistic as you might think. I mean, parts of them are. The parts that are unrealistic are if you see a lawyer in one of those TV dramas turn to the jury and just start talking. We don't get to do that, y'all. We get to talk to the jury in opening statement and closing argument. We don't get to do it during a cross-examination. No. So if you see them do that, it's like, nah, that's unrealistic. The reason most parts are realistic, these shows have excellent trial lawyers that they coach them. They tell them, do this, do that, stand here. I've seen some that are very realistic, like just being in federal court. It's almost like, that's exactly how you do it. The judges control lawyers a lot more in real life than you see on TV. And I mean, I know they have to because they've got to dramatize it and all that. I agree. But just know that if you see a lawyer get out of line, on TV, that's TV. Because in a real trial, you can't get out of line with the judge. Well, you can, but you first, you're going to probably be cited by contempt by the judge. And second, what jury is going to rule for your side if the judge is mad at you? So lawyers are very cognizant. We're very aware that juries think judges know it all and are wise and all knowledgeable, and they're the referee. And we can disagree with the call, but we can't protest it too much. Okay, so that's the end of my discussion about anatomy of a trial. I hope this information has been of some benefit to you tonight. Thank you.
Bob, I know it has been beneficial to everyone watching tonight, seeing a little bit behind the scenes of how a trial is really done. So much goes into it that laymen may not be aware of. We hope you've enjoyed our program tonight. People's Law School is brought to you by the folks at Prince Glover Hayes. We appreciate you watching and hope you'll join us next time for the People's Law School.
When you need an attorney, experience matters.
Past success matters.
Attention to detail matters.
Prince Glover Hayes is celebrating 40 years.
40 years as a civil litigation firm.
And delivers over 100 years.
Over 100 years of combined experience.
We've been able to obtain some of the largest jury verdicts and settlements in the state of Alabama for our clients.
We will fight.
We will fight.
We will fight to make sure our clients
get the justice they deserve.
Here at Prince Glover Hayes, we counsel.
We advocate.
we litigate,
and we are devoted to helping you.
People's Law School is brought to you by Prince Glover Hayes as a community outreach class offered by the Osher Lifelong Learning Institute.